is attorney TataNisha. Welcome to my show, Legal Kaleidoscope, on 910 AM Superstation, a division of Adele Media, Detroit's largest voice for African Americans. I'd like to first welcome my guest, attorney Dorothy Dean. Welcome. Thank you for coming today.
Well, thank you for inviting me.
Today, Dorothy and I, we're going to talk about what to do when the police stops you. What constitutional rights do you have as a citizen of the United States? As a juvenile, we have very specific laws that are enumerated for juvenile delinquents. Dorothy is in the NAACP Southfield chapter. Not only that, she's part of an Optimist Club, and she also has a special interest group. Dorothy, what is that special interest group you want to talk about today?
The Respectful Law group is a part of the Optimist group, and we go around to schools and we talk to youth to let them know what to expect and why they should respect the law so that they don't end up with a juvenile record.
Okay, and I hear that juvenile records can all be expunged. I think that's a myth. Are there some juvenile records that will stay with you forever? Are sentencing guidelines counted as an adult if you commit another crime, if you do commit a crime as a juvenile delinquent?
Yep. Actually, if you do commit a crime as a juvenile, and if that is not expunged by way of some type of a special rule, it's not called the Holmes Youthful Trainee Act, but there are diversionary programs for youth, but there has to be some type of consent and agreement by the prosecutor's office to not have that become a part of the juvenile's record.
Okay.
Yeah, usually the juvenile has to do certain things and comply and not get into any additional trouble or have any other incidents where they have contact with the law in order for it not to be there.
So it's not automatic.
It's not automatic.
And that is something that I hear all the time. If you have a juvenile record, it's automatically expunged. It doesn't follow you to your adulthood. What I'd like to do is give our listeners the phone number, 313-209-9000. 313-209-9000. We want to hear from you. Please join in our conversation. Now, Dorothy, can we talk about what does it mean to be designated? What does it mean when you commit a crime and you're 14? If I do an assault and battery versus if I do a home invasion when I'm 14, when is it that I will be charged as an adult? And when is it that I will remain in the juvenile court and be treated as a juvenile delinquent?
The general rule is that if you're 16 years or younger, most crimes will go through the juvenile system. However, if you commit a serious crime, you can be designated as an adult. So certain crimes, even though you're under that age, you can be designated as an adult.
Are they capital offenses? Are there enumerated crimes that are listed? Or is it a situation where the prosecutor can decide? Or do we have some crimes that are codified in law that the prosecutor doesn't even have an opportunity to say, yes, juvenile, no adult?
Actually, there are certain crimes. Let's just take as an example, a couple of years ago I had a juvenile who actually was in a threatening situation. So he made what's considered a homemade bomb, a cocktail, and threw it. And he endangered so many people in the community until he was designated as an adult, even though he was only 15, I believe, at the time.
So when you say designated, was he charged?
He was charged. There is a special hearing where...
What's the name of that hearing?
The designation hearing that the juvenile goes through before they even have a preliminary exam, if you will. There's that initial stage when you're charged with a crime.
Okay.
So the juvenile goes to the juvenile detention facility or wherever they're at and they face that crime, and then there's a special hearing to determine whether or not the juvenile is going to be designated as an adult.
Okay, now oftentimes there are waiver hearings as well. What is a waiver hearing in the juvenile justice system, and when is a waiver hearing? When does that hearing take place?
Well, there is a hearing to determine whether or not there is enough information to proceed with the charge. So Usually there's an opportunity to hold that hearing, and that's going to happen in the beginning stages of that proceeding with the juvenile.
Okay, that makes a lot of sense. Now, when you're a client, for example, what advice would you give the young people out here? The allegation that he made a bomb, he may or may not have made that bomb. So when the police come knocking at his door and they say, you have to let me in. Why? Because I'm a police officer and here is my badge. What do you tell your client at that point?
I tell all of my clients to please cooperate to the extent that you can, because we have authorized, when I say we, the country, we've authorized certain individuals to be responsible for investigating crimes and seeing what's going on. If you feel that you're wrongly charged, it's not wise to become belligerent and be uncooperative with the police, because there is something that's called obstructing, and so if you don't follow the actual what's required of an officer, then you can be actually charged with another crime, resisting arrest. And resisting arrest isn't just fighting someone, it could be not following those directions. So a lot of people don't understand that. They think, well, I was just asking questions and whatever. I have a right to know that.
Absolutely.
And they do have a right to know. Some officers will provide the info.
I want to reiterate what you just said, because if anybody's listening that's a youth or you have children, please explain to them what Dorothy Dean is saying. She's indicating that resisting arrest, what she said that was so important, it's not a physical resist. If an officer says, raise your hands, and you don't raise your hands, you can be charged with a felony of resisting arrest. I've had adults who were charged with felonies of resisting arrest. And what's so, in my opinion, egregious or unfair about this law is if it's two police officers and both say, raise your hands, and you put your hands down, you can be charged with 2 counts of resisting arrest. 2 felonious charges. But let's go back to when this police officer is at the door knocking with his badge, demanding entry. Would you tell your client to open the door and give that police officer consent to search his house? Or would you tell that client, do not allow a police officer to search your house if they do not, in fact, have a search warrant?
And that's the key point. I was going to say, depends on if they have a search warrant. If they have a search warrant, then you're going to comply with the search warrant. You're not going to make any statements to the police at that point, especially a juvenile, without your parents available and home, because there are issues that are going to arise. How old are you? What is your interpretation level of what someone asks you?
I have a question about what you just said. First, when you said especially a juvenile, let's reiterate anybody. It doesn't matter if you're a juvenile. It doesn't matter if you're 50. It doesn't matter if you're 80. If the police are at your door, do not make a statement. People minimize the Miranda. Do you find that?
And sometimes, and that's an interesting question, because I've had cases where Miranda rights were not given, and I say especially to juveniles, because they say, well, the juvenile wasn't under arrest. But I'm like, you have them come to the police station to make a statement, or you're asking them questions, they're not under arrest. So sometimes the officers will know the law much better than the individual.
Absolutely.
And especially when I say especially when it's a juvenile, because they have the right to have their parents there if they're 16 years or younger.
So if their parents are not there, as attorneys, do we have any recourse? Because oftentimes their parents are not with them, they are not present, and we can argue that it's a show of authority. What happens when we call, when the police officers come in and they take these people and they place them in interrogation rooms and they ask them so many questions, they say, well, they're not under arrest, but they're not free to go. We're going to get into that later. We're going to get into unreasonable searches and seizures. But right now we're going to go to the lines. It looks like we have Rodney on the line.
How you doing?
I'm excellent, Rodney. How are you?
Well, I'm fine. You got to tell the kids about stink bombs. Someone throws a stink bomb in the room and someone has an asthma attack and dies from it, somebody's in big trouble.
Oh, absolutely.
Yeah.
And that's what these kids don't understand. You are absolutely right, Rodney. They think that it's a joke, it's fun, it's funny, and it's a stink bomb. But if they have respiratory problems, asthma, COPD, you can have any type of problems that can arise out of a bomb. Suffocation in terms of gasping for air. We don't know what type of conditions that these individuals come to the table with. So what children think are funny or you think are funny actually can be a crime. But I like to also go into BB guns. I had a case, Rodney, where this individual, he tried to rob somebody with the BB gun. He was underage, but what kids don't understand is a BB gun to the law is just like a 9mm. If you rob somebody with a BB gun, you'll be charged with armed robbery. Just as a stink bomb, you're still charged with murder if somebody dies. It can be involuntary manslaughter. It could be premeditated murder if you know the individual has asthma. So, yes, you're absolutely right. I think that stink bombs are equally important. And what I do want these kids to know, do not carry BB guns because you can and will be charged as having a real firearm if you put somebody in imminent fear or danger. Rodney,
don't carry no gun. Don't carry none at all because that boy down in Cleveland, remember he had a fake gun and they killed him.
Absolutely. You can have Skittles and they kill you. You can have iced tea and they kill you. So you definitely should not have a BB gun or any type of gun. We're gonna go to
looks like a gun.
Exactly. Any weapon at all. And we're gonna go to break, Rodney. But we thank you for calling. Have your constitutional rights been violated by illegal search or seizure of your motor vehicle or home? Did you know that every parent has a fundamental right of parenting, which includes visitation? Call me to get the rights you deserve. I'm attorney TataNisha Reed. Innocent until proven guilty is your right, not just the same. My team of legal professionals will work aggressively to advocate your criminal and family matters and get your life back on track.
For a greater chance to succeed in your time of need, call attorney TataNisha Reed.
Welcome back, and thank you for listening to 910 AM Superstation. This is Legal Kaleidoscope with attorney TataNisha Reed and Dorothy Dean. When you look into the eye of the law, we all can see a different perspective. We have a caller. Hi, Larry. How are you?
Hi.
How are you today?
Oh, I'm fine. How are you today?
I'm excellent. Thank you. What's your question?
Good. My question. Now, I'm listening to you talk about all this guy talked about his crooked cases out in Novi, wherever he was at, and his special treatment that he got.
Mm-hmm.
Now, I mean, I know it's common practice in Detroit to get that treatment, but you go outside of Detroit, like you said, people think they're running from Detroit, moving out to the suburbs, but it is actually better out there. You get better police service, and it's like the police care about you out there. I mean, that's just one side of things that I see.
Okay, so like let's say Southfield, you get better city services, you get a better school district, you may get better rates on your insurance. So you're saying it's kind of a give and take situation if you move out of the city. You live in the city, your house can get broken into, your kid can get gunned down. So I do agree, you have to balance the equities when you're talking about living in different communities. Did you have a question?
Yes, I did. Now, if you have these officers, these crooked officers, they live in the suburbs and they work in Detroit.
Mm-hmm.
Now, they see these people on the streets, like you say, they see somebody because they know them and they pull them over and they mess with them.
Mm-hmm.
Now, do you think that, is that they have the right to do that just because they see you? Okay, I see this person, so let me see what's going on with him.
Absolutely not. Dorothy?
Absolutely not. There's something called probable cause, but the reality of it is that a lot of times the officers know the law, and so they get around it. They say you didn't quite stop at the stop sign,
or
there's some reason, because you can't just stop someone just because, and a lot of cases have been thrown out just for that reason. So you got to have probable cause just to stop someone. But if you know that, you could say, that person was straddling the line, so I think he or she may be intoxicated. They can come up with reasons to stop you, which then makes it, that issue, the threshold issue of, was there probable cause to stop you?
And that's why we have to really listen and educate our children. In Detroit, you can't walk in the streets. There's an ordinance that says it's a crime to walk in the streets. You can't spit on the sidewalk. You can't stand outside and hold a beer. After St. Patrick's Day, the court was flooded with tickets. People drinking in public. They're just standing outside the pub, standing outside the bar. But the one to me that I was taken aback, you can't walk in the streets. So if you're walking in the streets, Larry, the police can stop you. And of course, we all know this is totally pretext. It's totally ridiculous. I'm doing nothing. But because on the books here, it says that you can't walk in the streets, that's probable cause for a police officer to stop you because that's an ordinance violation that individuals are breaking. So it's very important to know what your local and your city ordinances are. It's very important to talk to young people and adults about what they are. But no, it's never appropriate to be harassed. But as you know, Larry, we get harassed all the time. Our children get harassed. Our adults get harassed. You have people in impoverished communities. It's not just an African American problem. I always say classism is the new racism. I think poorer people, impoverished people, they're getting harassed even if they are white or if they're Mexican. You have cultures of people now, the foreigners, they get harassed all the time because people come to the table with their racism and their prejudice on so many levels, and they mistreat individuals. And police officers, unfortunately, do it sometimes too.
And just to add to that, because in the past, we could never really show that a lot of this was going on. Now, with social media, people's cell phones,
Yes.
we're getting snapshots of what's really going on. So now you see an uproar throughout the country with some of these things that are going on. For instance, the young adult who had his hands up in the air and still was shot, not just once, several times. And but for it being caught on tape, the world would not have known about it. So now we're seeing time and time again, and it's because we have that opportunity to prove it that is happening. And so now we're seeing more people are getting involved and saying,
Yes.
this is not fair. We just want our children to be treated fairly.
Exactly. So I thank you for calling, Larry. We appreciate it. So, Dorothy, I think something that Larry said that was very important is that people are being harassed. I find that a lot in my practice. But before we dialogue about that, we have one more question from Manuel. Hi, Manuel. Thank you for calling.
Hi, thank you for taking my call. And hi to your co-host.
Hello there.
Now that we're on this subject, I just got a comment. This baseball season coming up. I want you to get your cell phones out. Everybody go down on opening day and want to see all these affluent suburbians come in, and they're going to be drinking out of public place. So you talk about this ordinance, and not one police officer is going to do anything to them. I even was told by a court clerk, told me that she worked for them, that on that day, do not write any tickets. That is the truth, and I believe it. I've seen it.
I believe it and I see it because, as we know, money makes the world go round. And what I think is very unfair when you have the St. Patty's Day or you have other days that people may or may not agree with or may not think are equally important or are not bringing in as much money to the city, you get the caveat, don't write tickets on this day, but on another day you don't. So what it does, it confuses people. It confuses citizens because people don't think that it is an ordinance or it is a violation to drink in public. Why? Because like you said, on opening day, I was drinking and it was okay. So why did I get a ticket on another day? You're right. It's just a reality that we deal with. Manuel.
Absolutely. Thank you.
Thank you for calling. Yes, Dorothy. And what people also don't realize, you get certain misdemeanors, you get certain felonies, and they could prohibit you from getting expungements. So sometimes people get different type of tickets and citations that are not civil infractions, and they think, oh, this is just a misdemeanor. I'll go to court, I'll plead out. But something else could come down the line, and that misdemeanor can prohibit them from getting a CPL maybe. It could prohibit them from or time frame they'll have to wait. It can prohibit them from a lot of different things. So just be really careful and don't just plead out to everything. Sometimes it pays to hire a lawyer. People always go to court. They always say it's small. And later on, they realize it's kind of big. And it pays to hire a lawyer if you can afford one.
And I really want to just expand on that, because I've seen so many cases where it's a second offense and the first offense should have been something that was a diversion or a 7411 where it's not on your record, but
Yes.
no, the person just listened, took a deal without counsel to realize that could have been permanently removed from their record. So then they have a conviction already, and they've already utilized that first opportunity to have it off their record. So
Absolutely. If you can't afford to hire a lawyer, you pay us to have your best interest at heart. We have a caller. Cheryl, how are you today?
Hi, I want to thank you all for educating our community, first of all. I got a question for you.
Yes.
What do you do when you go to a law firm and you sign a contract and you hire one particular attorney, but someone else get on your case without your permission, go to court, you don't know anything what's going on, and get your case dismissed? What do you do, and what can you do with an attorney that get on your case that you don't know nothing about and you think he made a deal with the other party?
Okay, it's a couple things here. What we do a lot as lawyers, what's commonplace, is we send stand-ins. For example, if I have a very busy docket, I can call Dorothy. I say, hey, Dorothy, can you stand in on this case for me? And I'll stand in on a case for her. So the issue shouldn't be that the lawyer sent a stand-in. The issue should be the quality of representation that you received. If you receive representation that was subpar, what you could do is hire another lawyer, and you could have a claim of ineffective assistance of counsel. What that means is that what that lawyer did fell below industry standards, and you can ask for your new attorney to do a motion of reconsideration or a motion for the judge to vacate the verdict or to vacate whatever conviction because the prior lawyer was ineffective. But I don't want you to focus on him sending someone else, because if I send Dorothy Dean is overly prepared every time I ask her to stand in for me. It makes me chuckle on the inside. She knows so much about the case. I'll tell her a few facts and she looks up all the law. So it just depends on who the stand-in is. Any lawyer, if you pay the lawyer and they show up, they have a duty to be prepared. So you can ineffective assistance of counsel them if that lawyer is not prepared.
Thank you so much.
Absolutely. It's my pleasure. Okay, we're going to go to break right now. We'll be right back.
So, Sam, I heard your grandma say they're donating that car to Charity Motors. Yep. Said they're getting a full fair market tax deduction for it?
I do not know what that means.
It means we get whatever it's worth as a tax deduction, right when we donate it.
Nope, not getting it.
It means we get money for it. So does the charity we pick. And the car goes half off to someone who really needs it.
Dollar bills, Sam. Whoop, whoop. Charity Motors.
Yep.
Welcome back, and thank you for watching and listening to 910 Superstation Radio Our Way Adult Radio Broadcast Group. We have a caller. Hello, caller. How are you?
Attorney TataNisha.
Yes.
Two statements and a question.
Mm-hmm.
First of all, let me say that your show last week, you need to do parts 2, 3, 4, 5, and 6, because we have a lot of people dealing in the world of topless dancing, and they need to hear realities of the pros and cons and disadvantages of. Great show.
Thank you. And actually, I am going to do more series on sex and the law. I just wanted to break it up.
Well, second of all, I like to say the fact that you're pointing out examples. Our kids, our adults, people, period, in law need to have examples. An example I give you is when I served on jury duty for my very first time. It was a brother that went back to his old neighborhood, and he saw two of his old friends. They asked him for a ride. He gave them a ride, and they asked him to drop him off at a corner and said they'll be right back. They went around the corner and robbed the bank.
Tell it.
Came back, got in the car, drove off, and he partied with them that night, and they got arrested that same night. He's in jail right now. So I think the examples, when people they tend to understand. They may not understand the legal verbiage that you give them, but examples of how quickly you can get into trouble, they get that.
What's your
now,
name, sir?
The next thing,
My name is Steve.
Thank you. Thank you for calling, Steve. And the reason I asked your name is because what you're saying is of paramount importance. Continue.
Now, let me say what happened to us. We have a walkers group, and we were walking in Hines Park.
Mm-hmm.
One woman was carrying a golf club. Another woman was carrying a stick. Another woman was carrying pepper spray. Police officer pulls over, said he could arrest us because of the golf club and the stick, and he looked at the content of pepper in the pepper spray to see if it was legal or not.
Mm-hmm.
What do you suggest a person or woman should carry if she does not have a CCW? How do we protect ourselves? Because I heard you give the example of the taser. I always thought you can carry a taser.
No, a
I
taser
always
is
thought
a
you could
legal
walk with a
weapon.
golf club. I always thought you could walk with a golf club or a stick to protect yourself.
Now, I do believe that officer gave you erroneous information indicating that you can't have a golf club or a stick. What you can't do is assault someone with a golf club or a stick. But a golf club and a stick are legal, and you are well within your right to carry one. Would you agree or disagree, Dorothy?
I would agree with that. It's only if you use it in a violent way, then it's considered a weapon. So how you're using it, but just a golf club and a stick in of itself, that's not illegal. And not grounds for any probable cause to do anything other than to play golf and walk around with a stick.
They were harassing you. But one thing I want to say, Steve, that you said about the example with the young boys when the one was dropped off, the youth need to know we have two doctrines. One is called accessory after the fact. So let's say those two guys, they go and they rob somebody, and they come back and they give the boy who didn't even know that they were originally robbing somebody their clothes. And they say, we had on this white shirt. Take this white shirt, go home and wash it. Go home and put it in the garbage can. The moment that young boy does that, he's committed a felony. It's called accessory after the fact. If you help somebody even after they committed a crime, you still can be charged with a felony. And if you aid and abet someone. If you drive a car and I go murder somebody, if you never touch the gun, you're still charged with murder because you helped me co-conspire to commit murder by driving me there. So I want everyone to know, just being there and helping me commit a crime, you can be charged with the exact same crime. Thank you again for watching and listening to Legal Kaleidoscope. We are live on the air at 9:10 a.m. Superstation. We are wrapping up right now, so I'd like to thank all of the callers. I appreciate the community. I appreciate the Tri-County area for listening to me, for calling in, for asking questions, because knowledge is power, and we have to arm our children. We have to arm our adults. We have to arm our community with knowledge, because this is what's going to make a better Detroit and a better community. Thank you again, Dorothy Dean, for coming. I appreciate you. I'd like to again thank Denise Doty Johnson, Kevin Adele for having me. Watch me on WADL Channel 38 every Saturday at 11 o'clock. Tune in every Saturday 4 to 5 here at 9:10 a.m. Superstation. Thank you.